Hi guys, welcome to the channel. My name is Niladri Mukherjee and I'm a regulated Canadian immigration consultant. I practice here in Guelph, Ontario. What if my visa gets rejected? Then what options do I have? Can I appeal to the Federal Court of Canada? Can I apply for judicial review? Or what options do I have? This is the most commonly asked question these days because of the number of rejections that we see for most number of visas to Canada, be it a study visa, be it a work visa, be it a visitor visa. The number of rejections across the country have really gone up, which is pretty much understandable because the number of applications have gone up as well. So the number of rejections almost always have a direct correlation with the number of applications, right? So the point that I'm trying to discuss today is that what logical steps you have, what logical options do you have once your visa gets rejected, right? So regardless of what visa gets rejected, the most scientific way to approach this will be to apply for a case note or to apply for what is called a GCMS notes. That note will ideally give you a complete understanding about what really has went wrong, what the officers have thought about your case while rejecting the application. Now, keep in mind the current waiting time to to procure a GCMS notes is quite very high. As of right now, it is taking in between 2 to 3 months to get access to the GCMS notes. Now, imagine you want to come to Canada as a visitor in this summer, right? So you really have a month or two to apply for the visa one more time and then get a positive decision and then book your flights to travel to Canada. Now, do you really have time to apply for a GCMS notes at this point in time? Probably no, right? So it may be a good idea then to just introspect, review the application. If you have hired a consultant, work with them. If you want to come to me for a consultation, have me review that application to let you know what really has gone wrong and then to reapply for the same, right? So first step is to apply for a GCMS note. The second most logical step in 99% of the time is to apply one more time, which is called a reapplication. Regardless of the application, be it a visitor visa, be it a study visa, or even a work visa, you should look into the reapplication mode rather than going for the judicial review mode or the appeal mode, right? If we talk about really appeal, so can I appeal to the Federal Court of Canada for any rejection that I face? The straightforward answer to that question is no. Being a foreign national, I'm assuming that you are a foreign national, you do not have any right, I repeat, you do not have any legal right to appeal a rejection decision. Whatever decision that you get is the final decision, right? The right of appeal is given to the Canadian permanent residents and the Canadian citizens under very, very specific circumstances. So being a foreign national, you do not have any appeal right. So appealing a decision to the Federal Court of Canada is out of question if you are a foreign national. Now, the second most commonly asked question is a judicial review. Sometimes I see that people do not really understand what a judicial review is and what an appeal is and what really is a difference or what are the key differences between an appeal and a judicial review. So if you are a foreign national, as I had said, you just have two options, right? One is a reapplication, the other is the judicial review, right? So you do not have an appeal option anyways. Now, what is a judicial review? Judicial review is a legal request to the Federal Court of Canada that you can put through either through an RCIC or an immigration lawyer, by virtue of which you are basically requesting the Federal Court of Canada to appoint one more visa officer to review the exact same application that you have submitted. And in that judicial review process, important for you to understand is that you cannot have the officer or cannot have a new officer to review a new application for you. So a Federal Court of Canada, if the appeal for judicial review, if your application for judicial review is granted, the Federal Court of Canada in that case will appoint a different immigration officer to review the exact same application that you have submitted. This is the key difference between an appeal and a judicial review, is that in the judicial review, another officer is reviewing the same application. In that appeal, you are allowed to submit any new proof, you are allowed to submit any new statement or anything else. But as a foreign national, you do not have an appeal right anyways. So between a reapplication, which means submitting an application one more time, and a judicial review, 99% of the times I request my clients or I request anybody that comes through a consultation to go for the reapplication process rather than going through the judicial review process. The reason for that is not that that judicial review is not as effective as a reapplication. No, judicial review is a very, very expensive process. You have to keep in mind, right? The second most important reason as to why do I not request anybody to go for the judicial review process is that that judicial review application has to be that strong for the Federal Court of Canada to first of all hear your application. So you're making an application and the Federal Court of Canada is hearing your application are very two different things, right? So your application for judicial review has to be that strong for the Federal Court of Canada to set aside other hearings to hear your case or to read through your application. That is the first step. Second step, your application has to be that much stronger for a Federal Court of Canada to understand that your previous application, your previous decision on the application was actually so incorrect that it should appoint one more officer to review the application. Now, if you think logically, if you think sensibly for a second, it's not really that much practical unless and until the decision is so unjust, unless and until the decision is absolutely ridiculous. It's a radical decision that you have received. A Federal Court of Canada does not really approve the request for judicial review that very often, particularly in these days where there is already a long list of long cases of hearing that have been pending for a long time because of COVID. Now, another thing that you should keep in mind that while going for a judicial review, you do not always need an immigration lawyer. An RCIC such as myself, I'm not an immigration lawyer. Just to repeat, I'm an RCIC, I'm an immigration consultant. I have the right to take your case into the Federal Court of Canada for judicial review. This is also a confusion that I see many clients have, that you need an immigration lawyer for a judicial review. Well, you can have an immigration lawyer for judicial review, but that is not mandatory. Anybody that is licensed immigration lawyer, immigration consultant such as myself, will also have the right to take your case into the Federal Court of Canada for judicial review. It is a lot more expensive process. In that process, all the consultants, all the lawyers make a lot more money because honestly speaking, that process is very, very technical, is very, very complicated. And as a foreign national, I see most of the clients really do not have that much amount of money. Neither I believe they should go for the judicial review an option, as I've said most of the times. So a reapplication is really what you are looking at. A reapplication, does a reapplication help? Well, it does help if the reapplication is proper. It depends, again, a lot of factors just come into play here. Why the application got rejected, what kind of application got rejected, should you really reapply, or should you at all go for a judicial review? Should you reapply with the GCMS notes? Should you reapply without the GCMS notes? A lot of factors come into play once an application gets rejected. So if you need me to support with your reapplication process, it may be a good idea to come for a consultation to have me review all these applications to take care of the next course of action if you need me to do that. But having said that, just to nutshell, as a foreign national, you do not have an appeal right. You will end up with a judicial review and a reapplication. Judicial review means the same application is being reviewed by another officer if the Federal Court of Canada agrees. Reapplication means you're submitting a whole new application one more time, which obviously logically gives you way more opportunity to present your case in a different manner. And a reapplication typically costs 1/3, if not half, as what compared to what a judicial review would cost. I hope this clarifies the situation. If you need my professional assistance, drop me a line, contact at nuvonation.ca. Shall be glad to assist. Thank you guys, and I'll see you in the next video. Bye now.